This is Law with Charlie, hosted by Charlie Medcalf. This is your podcast and YouTube channel for all things law, legal academia, and qualifying as a barrister.
Hello and welcome back to my podcast, Law with Charlie. This is Charlie Medcalf speaking, and welcome to what is my fourth episode overall, and my third episode in my Save Our Juries series. And so today I'm going to continue my discussion on why juries are so important and why actually the government's plans to abolish juries for most criminal trials in England and Wales is a very bad idea. It's the wrong way to go. And this episode is really an episode I was not really thinking about recording. This wasn't an episode I had on my radar at all. I'm recording this episode on, let me just check the date, Monday the 15th of December, ready for publication tomorrow, Tuesday the 16th of December. And I thought about doing this episode at about, sometime between 1 and 4 o'clock today. And that's when I was thinking of doing this episode. And so this has been a very much last minute episode idea. And I'm going to give you a bit of details now. Why this episode? Why today? And why so suddenly did it come to my mind? Well, this week I've been really lucky in securing mini pupillage at a barrister's chambers somewhere in England and Wales, I'm going to say, because you don't need to know exactly where it is. And as part of this, the barrister's chambers didn't have anything for me to do in the morning, so I went to the Crown Court in this area, somewhere in England and Wales, and I was sat in randomly in a criminal trial, because in this place they often have both criminal trials as well as the county court, family courts and all that in one place. And so I went to have a look, observe this criminal trial, and I've actually struck very lucky, because this was clearly Monday morning, and so it was the start of a new week, and as such it was very much the start of trials. And I had come into a trial which was very much starting that day. When I walked in, they were just preparing for the judge to walk in and then for the jury to come in. But this trial started with the jury being elected, basically deciding which jury members were going to be sat through this case. So that was all really interesting, because I haven't seen that before. But this isn't really the substance of my argument in this episode. And believe it or not, especially considering my position on jury trials, none of the things I'm going to mention in this episode is about the juries. The juries had no involvement in any of the problems or any of the things which arose in this trial. The jury were just there doing their job, and yes, I think really the jury were limited because of the failures or mistakes of other parties, shall we say. And I'm not going to even say what this particular criminal case was about, because again, that's not relevant either. You don't need to know what this case is about. You don't need to know who's been involved. You do not need to know where this was happening. You don't need to know anything about the case specifically. What you need to know about is why were there so many delays? Or what was being done to prevent delays? And who was responsible for these delays, essentially? And so the judge said at the very start of this case that this case is of utmost importance. It's starting on this Monday, and he hopes to get it all complete by Friday this week. But then they're not here in this case on Wednesday due to other circumstances. And so the trial judge in this case is extremely keen to get all of this case complete by Friday, and as such is treating it as of the utmost importance. Likewise, he apparently told the prosecuting barrister last Monday that it was of utmost importance that everything was ready on time, all the witnesses were aware of where they needed to be and when. This was because they were aware that they might face some difficulties with some of the witnesses, something I will come back to very, very soon. But yeah, the judge was extremely keen in ensuring that this case is a priority for everyone involved and it gets through court this week. Now, the judge's enthusiasm is good, although I have to admit this was the first time I've ever sat in a criminal court in England and Wales where I felt somewhat intimidated myself. Very much intimidated because of the judge. He was very much telling off the poor prosecuting barrister. But he had a point, you would argue. I would say that maybe this is because of the news regarding juries. That maybe the judiciary have realised that there's a need to essentially not waste time. A need to get these cases through the courts. A need to try and prevent any more backlogs, because the backlogs, as I'm sure you are aware, are absolutely terrible in the criminal courts. And so yes, the judge was a bit intimidating, at least this morning. He got better in the afternoon, although I did have some time away during my mini pupillage for part of the day. But yeah, so the judge was really, really, really passionate about getting this case onwards and upwards. And so there was many ways he tried to ensure this. So firstly, there was maybe not an issue, but maybe a matter of law which the prosecuting barrister wanted to raise, but he would not let her raise it before delivering at least part of her opening speech, which, fair enough, I would say. But really, that's just showing how the judge was keen to get the jury hearing about what the case was about and all that. Let's now actually go into what were some of the problems of this case. Why weren't people why wasn't the judge happy? Why were barristers being told off? So, in this case, there's been a lot of witnesses called already, and various problems have occurred. So, the first problem is the first witness was an intimidated witness, meaning he was able to be behind a screen. Well, I say he, I don't know if it was a he or she, they were able to be behind the screen. And they were meant to be the prosecution's first witness. However, they parked in somewhere where they had limited parking, an hour or two I think it was, and it was about to run out by the time they were making their way to the courtroom. And so essentially, they had to let this individual go to move his car into the court car park, which then delayed time, and then we had to call, well, not we, the prosecution had to call another witness instead, one of the police officers. And I left halfway, well, I don't know how far through, but I left towards the start of the prosecution's questioning examination in chief, unfortunately. So at least there was a witness ready and waiting, I suppose, to be questioned. So that was all good, but that comes to the first issue. Witnesses, and in this case, parking, really. And so the courts require witnesses to show up to cases. They are legally obliged to come to the courts, and to give evidence. And so could there be a bit more which the courts could be doing? For instance, providing witnesses with access to the court car parks from the start or something. Surely that would then help decrease delay and these occasions like running out of parking time and the risk of getting a parking ticket from arising. But then, let me just backtrack and to the point where no witnesses had yet been called. There was a need to send the relevant witnesses the relevant summonses, essentially telling them that they are expected in court at a certain time and in a certain place. Apparently only one of these had been served, and so the judge demanded that the rest of them be served, and if need be, get the witnesses arrested, so then they could come to court. And so I haven't heard any more of those events, but essentially there's two witnesses who I will come back to a bit later actually. But yeah, the judge wasn't happy, and apparently he got onto the phone to the chief constable because of how the summonses had not all been summoned and how the individuals were not at court. So yeah, that was very much the morning part of it. Now let's go back to the afternoon part. And this was when I next came into this case, was when the witness, the intimidated witness behind the screen, was given evidence. And I came towards the end of the prosecution's evidence. And here, this is actually not really any issues, because this was an intimidated witness, there was a court-appointed barrister to do the cross-examination on behalf of the defendant. And that all went very well, very smoothly from what I saw, and so no problems there. Although, all the problems then started once again after this witness. So, firstly, all of the witnesses following this intimidated witness were apparently waiting miles away from the actual courtroom, and the judge requested that all the relevant witnesses were standing outside of the court doors ready to come in on time so as not to waste any time at all. But the first witness and one police officer came in after a bit of a wait, and even after they had given their evidence, they were still waiting, and it was only after that second witness did the message get to the relevant people that the witnesses for this case had to be outside the court door and not hundreds of miles away, and that the judge had to be obeyed. And so I will come back to the witness in just a moment, because I've just remembered another aspect which I completely forgot from the morning part. The judge left the courtroom for a brief period, as did the jury. And during this short time, because it was very short, when the judge wasn't present in the courtroom, the officer who sits/stands with the defendant had sent the defendant back down to the cells, and so then the judge had to call the defendant back and had to have a bit of a go, just a slight go at the relevant officer, because he said that the defendant should only be taken down when he says so. And so I'm not saying the judge was unreasonable at all. I think the judge was very reasonable, but essentially listen to the judge, essentially, because this wasted a surprising amount of time. Actually, it wasn't like ages and ages, but it was still time wasted because of the actions of other people. But then, getting back to this afternoon session, the first police officer, he came in and gave evidence, and then I believe the defendant did have some questions for this witness, so fair enough. But then the next witness came in. The prosecution had very few questions, and the defendant did not have any questions whatsoever. The judge was not happy at all about this. And I was, as a law student who knows a bit about the criminal justice process, I was absolutely mortified, you could say, that the defendant didn't have any questions for this witness. And yes, although you could say this was potentially because of how I'm thinking legally and I could ask the relevant witness many questions, I think I probably could, and that this person was a litigant in person representing himself. I don't think I've told you that bit, but yeah, the defendant in this case, they are representing themselves, and they said for this one witness that no, they didn't have any questions. Now, why is this a problem? This is a problem because you only call witnesses to a trial when their evidence is disputed. That's to say that witnesses are only called to trial where the prosecution say one thing about this witness, but the defence dispute what this witness says. And so this provides the relevant witness a chance to share their story in person, and for the defence to then challenge their evidence, test their evidence, and really see how accurate their evidence is. However, when such witnesses' testimony, when their evidence is not contested, then they should not be brought to court. It's a waste of court time for one, and it's a waste of the witnesses' time as well. And in these situations, it's often that their witness testimony is just read out in court because the facts are undisputed. It's only where the facts of a witness's evidence are disputed that a witness should be called so they can be examined in chief, then cross-examined, then re-examined if need be. Then after that witness was very quickly departed from the courtroom, there was another witness. This was someone from the relevant counsel in regards to the CCTV evidence. Now, I have never known anyone, such as a CCTV operator, whatever they are, to be involved in such trials, i.e. given evidence. And there was no need for this individual to be given evidence either. The prosecution asked a few questions, and there was a lot of discussion about just trying to find the location of where this camera was in relation to the crime scene and all that. And then once the prosecution had finished their questions, which were very, very minimal, it was for the defence, i.e. the defendant, to provide their questions. And the defendant did not have any questions for this witness, meaning that's at least two witnesses who came to court to give evidence when they didn't need to give evidence because the evidence was undisputed and the defendant didn't have any questions for them. And I think that happened to a third witness as well. And so this is another delay. Again, not the jury. The jury were there sitting, watching, listening to the evidence, which is their role, and they didn't really delay the trial at all at this stage. The trial at this stage was delayed, or at least prolonged, because of the defendant. A, because of his lack of legal knowledge and him representing them himself, and also calling witnesses whose testimony is not disputed and for which the defendant had no questions for them. So that's another aspect of why this trial was delayed. Much to the judge's discontent, the judge was not happy at all. And then we get to what's potentially some of the meatiest parts of this case. Now, in this case, there are two witnesses, and cut long story short, they've been lost, they cannot be located, they cannot be found. The judge heard about this last week and told the prosecution barrister to find them, essentially, get summonses issued and make sure they are at court for the start of this trial today, because this trial is of paramount importance. It's a priority, as the judge was making clear throughout the day. There were still problems this morning in terms of the trial, in terms of the witnesses, they still hadn't been found, and nobody knew where they were, and they were not at the courtroom, and they were supposed to give evidence today. However, they were not at the courtroom. This was 4 o'clock. The judge previously told the jury that they would finish the day at about 4:45 because of how important this case is, and to ensure that as much of the evidence as possible was got through today, and so the trial could try and be over and done with by Friday. But no, these witnesses were not present, meaning the judge had to end the jury's day at about 4 o'clock, meaning they missed 45 minutes, and that's arguably the greatest amount of time lost in this trial overall today, and 45 minutes is a significant amount of time. And so this really, I would say, strengthens my argument that the delays in the criminal justice system are not because of the juries. In this case, the main delay is because the witnesses were not where they needed to be, i.e. they can't be located. And the judge has made it very clear that if these witnesses are not present at court tomorrow morning, and I really, really hope to be there to watch their testimony, because I think this case is just going to get better and better. He said, essentially, he will, and excuse my language, this isn't what the judge said, this is how I'm interpreting it, how I'm talking about it. He'll be giving a bollocking to the top person at the CPS, as well as the top person of the police force. And so the judge, rightly, is not happy at all with how these witnesses have not been located and have not been at court. And essentially the prosecution had all of last week to try and avoid this. The prosecution had all of this time to ensure the witnesses were where they needed to be at the right time. But they hadn't. The 2 witnesses who were waiting for were not in the court today. Many of the other witnesses were not where they needed to be today. Not all of the police officer witnesses were present for their evidence today. And this led to a load of delays, and it also led to the poor young prosecuting barrister having quite a hard day in court today with the judge. Now, I can only feel sorry for that barrister, because although the judge had a very good point, this career is stressful. Being a barrister is not easy, and I appreciate how difficult their job is, and I can appreciate why all of these problems may have arisen. And I'm not, I don't think the prosecuting barrister is necessarily fully guilty. Well, of course they are. Of course they're fully responsible, but for a law student who's looking at being a barrister, for instance, you have to appreciate the caseload and the stress which they are subjected to. But let's just put this in context. This barrister works for the CPS, the Crown Prosecution Service, who prosecute most of the criminal trials in England and Wales. And the CPS is a public prosecuting authority. They are publicly funded. And so the CPS have resources which normal private citizens do not have. And so, even if this particular barrister was not able to ensure that the relevant witnesses were at the court on time when they needed to be there. Arguably somebody from the CPS could have ensured they were. And so, again, this has really shown that it's really not the juries. It's the system failing. It's the criminal justice system collapsing, the justice system collapsing. And why is the justice system collapsing? Barristers are overworked. The money they get for it is minimal. If, for those who want to be barristers, you do not go into criminal law for the money, there is none. Many times you're often paying to work, and at times you're not even getting paid the minimum wage or national living wage to be a criminal barrister, which is absolutely terrible and is a problem in itself, and probably something I will discuss again at a later date. And so that's one of the issues. Then funding in general. The justice system has been under strain due to government funding cuts. The problem, again, I repeat, is not the juries. The government need to fund the justice system. And also, having courts open and ready to be hearing trials, having more judges or magistrates available to be hearing these trials, and probably most importantly, ensuring that there are no technical difficulties, which luckily for me, there wasn't much evidence of today in the cases I witnessed, well observed, and ensuring that witnesses are where they need to be when they need to be, and if they are not where they need to be when they need to be, have measures in place to essentially enforce them to be in a certain place at a certain time, rather than wasting what in this case was 45 minutes waiting for the next court day to really find these witnesses and essentially wait and see what happens tomorrow. And so I think the main points I've mentioned here are money. We need money in the justice system, particularly the criminal justice system. There needs to be thinking of how you can get witnesses to the courtroom when they need to be there, and what will the consequences be if they're not. And finally, make sure the courtrooms are open, because the more courtrooms, the more cases get through, the better. But you could have as many criminal cases as you like. It will not get any better if these delays are not dealt with. And I repeat for the 100th time or whatnot in this podcast, the problem isn't the jurors. The jurors are not wasting the time. It's everything else. It's all the other delays, largely because of the witnesses or the defendants. And it's not always the witnesses or the defendants' fault. There's many different people, many different organisations, many different reasons why things go wrong. It's often not the jury though, at least in my experience, and I think many criminal law barristers would agree with me on that. Now, I think we're getting towards the end of this podcast episode, and you're probably thinking, I am all for juries. Yes, I am, and that maybe I'm biased. Maybe I'm looking at this case in a much more negative light than I should be. Maybe I'm just pointing out all of the negative parts and none of the positive parts. And yes, to an extent, I am. There were some, albeit minimal, good things about this case, i.e. many, in the afternoon sitting when I got there, many of the police witnesses were there, ready, although not as quickly as the judge wanted, which fair enough, we were still waiting for them, but that's normal in the courts. But I wanted to really provide you a way to do further research into this matter, and also for me to demonstrate this isn't unusual, this isn't just this one certain case, this isn't just this really important case because it's a top priority case which needs to be done by Friday. None of that is really the cause, none of it's really the reason at all. And this is actually very common issues, which you may have picked up from my previous podcast episodes. But if you're interested in hearing more about the failures and the limitations of the justice system, whilst also learning more about the justice system and looking at certain types of cases, i.e. rape trials in particular, from a different angle, an academic angle, looking at rape prosecutions and cases. And if you just want an experience of being in a courtroom without actually being in a courtroom, I would highly, highly recommend Dr. Candida Saunders' podcast, Criminal Justice in Action. In this podcast, Dr. Candida Saunders goes through a number of rape trials. So I'm just having a look through the list now. 1, 2, 3, 4 cases she has covered so far, and I'm at the start of the 4th case now. And Dr. Candida Saunders' podcast is absolutely amazing. It's like being in a courtroom without having to be there. If you're a law student, it's a must listen to. If you're an interested member of the public, again, a must listen to. And as well as all the things it does discuss, there's also quite a bit of consideration about areas where time is essentially wasted, essentially. For instance, the main biggest problem in this podcast is technical difficulties, which so far I haven't witnessed in my cases I'm observing. But yeah, that's another source of information where you could listen to their podcasts and really make a judgment for yourself. But also, if you don't want to listen to podcasts, or you want something extra as well as podcasts, for instance, if you like read the Secret Barrister's books. You can probably read their blog posts as well on their website, but read the books of the Secret Barrister. I would say particularly their first book, Stories of the Law and How It's Gone Wrong, I think it's called, because in this book, the Secret Barrister discusses immensely in lots of detail the failures of the criminal justice system, why the criminal justice system does not work, what's gone wrong, what's not working, etc., etc. And the Secret Barrister goes in detail of why there are so many delays, why there are so many problems in the justice system. And so if you are interested, I would thoroughly recommend those sources, both Dr. Candida Saunders' podcast and the Secret Barrister's books, other than the content I've spoken about today, are extremely good pieces of literature and podcasts, and so I would highly recommend. But I think that very much brings me to a close for this podcast episode, and I look forward to doing another podcast episode very, very soon. I don't know what the next one will be about now. It might be another podcast episode on my arguments why juries are not the problem. If it is that, it might be another podcast episode like this, where I talk about my observations from the criminal courts, from observing them. Or it might be another planned episode in this mini-series, if you like, of why juries are so important. Or it could be something completely different. You're going to have to wait and see to find out. And so please do follow me on whichever platform you listen to your podcasts. Send me a comment. It's always great to hear from you. Also, please do rate it, because if you rate my podcasts, it will help other people to locate this podcast, which is what I need. I need people to be finding this so they can find a reliable source of legal knowledge. And also, this is just a great podcast, I would argue. I could, of course, be biased, though. But also, if you're listening to this on a platform which is not YouTube, then please do check out my YouTube channel as well. It goes under the same name, Law with Charlie. My podcast is also available on YouTube. But essentially, on my YouTube channel, there's much more content. Both podcasts like this, but also videos of essential cases in law, public lectures on law, lectures of certain areas of law. There's just general discussions about law. Basically, it's all things law, and so please do go to my YouTube channel, like my various videos. Please do subscribe so you don't miss any of my content, and also leave me a comment. It's always great when I hear from my listeners and watchers, and so please do leave me a comment, whether it's just saying hello or if you're wanting to ask me a question, and I will try my very best to get back to you as quickly as possible. But I think that's all for now, and I will conclude there. So thank you once again for listening, and I look forward to talking to you again in my next podcast episode. Thank you and goodbye.
Thank you for listening to Law with Charlie, with your host, Charlie Medcalf. Please do ensure that you leave a comment below, either to just say hello or ask a question. And please like, subscribe, and leave a review for more content like this. See you next time.